Good morning. My name is Erin Torsello. I'm a labor and employment attorney here at Bonchenek and King. Welcome to the seminar, Wage and Hour Traps for the Manufacturing Industry. This is the third in our 5 presentations that we have lined up for you guys this week. Hopefully you were able to see the presentations on cybersecurity on Monday and protecting your manufacturing business from IP theft yesterday. And then for the remainder of the week, we have an OSHA seminar on Thursday and an immigration seminar on Friday. So today, I want to first walk you guys through the presentation. We're going to start with first the legal basics of the wage and hour laws, federal and state. We'll talk about some common wage and hour issues that manufacturing employers tend to see. And throughout the presentation, as we talk through some of those challenges and mistakes, we will also talk through some best practices. Typically, when I present, I like to take questions throughout. Given the format, and you guys can obviously type your questions, but because of that, just for the flow of the presentation, I think it'll be easier to try and answer questions at the end. So please feel free to type in your questions and send them along, but I will try and wait to answer them until the end of the presentation. So do you really need to be concerned about wage and hour issues? And the answer is yes. And the reason is, as demonstrated here by a number of the articles which we've collected, the liability and the risk for class action lawsuits is high, and the dollar values can be high. As you can see here, in some of the examples of articles that we pulled, wage and hour class action lawsuits are hitting employers in every industry, every type of employee, and the types of issues that are being sued on run the gamut, and they can become expensive. FLSA class actions are on the rise. Since 2011, there has been a proliferation of wage and hour class action lawsuits. It peaked in 2015 with approximately 8,700 wage and hour class actions filed in federal or state court. In 2016, that number dropped a little bit, but this was the first decrease that we've seen in probably 15 years or so. And what's the big deal? Why are class action wage and hour lawsuits so scary? Why are they so risky? The damages are significant. In addition to any back wages that you may owe, the courts and the state and federal Department of Labor also assess 100% liquidated damages. So that automatically doubles whatever the amount of your back wages are. Liquidated damages are automatic unless there's a showing that you as the employer acted in good faith. Good faith is a very difficult standard to meet. What that means is that the court has to find that you thought you were complying with the law, and it's not just a misinterpretation of the law, but that you had a reason to believe that the practice that you were following was lawful. That might be shown by establishing that you are following a practice or procedure that the Department of Labor had signed off on. You might be able to argue that you are following legal advice. But in either event, I actually had the opportunity to do research on this recently, and I did not see a case where the good faith defense was successfully argued. It wasn't exhaustive, but employers always assert it, and I have not yet seen a case where it was successful. So typically that 100% liquidated damages will be automatic. In addition to those two things, attorney's fees and civil penalties can also be assessed. The other the other thing that goes into this calculation is the statute of limitations. Under the FLSA, the statute of limitations is 2 years or potentially 3 years if there is a willful violation. A willful violation is established where the employer knew or should have known that their actions were not lawful. Their actions were intentional or deliberate. They intentionally or deliberately did not follow the law. There has to be a showing that it's more than mere negligence or that the employer misinterpreted the law. There has to be some additional intent to try and not comply with the law. In New York, if there's a New York wage and hour claim that's at issue, the statute of limitations is 6 years, meaning that the employee can try and collect back wages for a 6-year period of time. So obviously with that, that means that the damages that you might face just from a monetary standpoint can be multiplied because you're talking about between anywhere from 2 to 6 years that you might be liable. Let's talk a little bit about what the legal basics are here, what the federal and state legal framework is, what the statutes are that are in play. The first, as I'm sure you've all heard of, is the FLSA, the Fair Labor Standards Act. The FLSA was first signed into law by FDR in 1938. It provided for minimum wage, overtime pay, record keeping, and also put restrictions on the use of child labor. Just by way of historical background, this was a New Deal legislation. And the reason that overtime was implemented was to try and encourage employment of new employees, not just existing employees. So what you had was a lot of employers working employees 60, 70, 80 hours a week. And what the federal government wanted to try and do was increase the number of employees who had jobs, or number of people who had jobs. The way to do that was to put a premium on hours worked over 40. New York State has also chimed in. So New York State labor law also provides for minimum wages. They also have regulations and requirements concerning overtime pay, record keeping, and they also have their own set of laws concerning child labor. Generally, New York State law is stricter than the requirements found under the FLSA, and we'll get to that in 1 second as we talk through even just the basic minimum wage questions. So under the federal law, currently the federal minimum wage is only $7.25. What that means is that any employee who is not exempt, meaning they are paid on an hourly basis, must receive overtime pay for all hours worked over 40 in a work week, and they have to be paid at least $7.25 for those hours under 40. New York State, however, as I indicated, has stricter requirements. So in New York, currently the minimum wage is $9.70 per hour. However, as many of you are probably aware, New York has a recently passed regulations last year, actually, which slowly and incrementally increased the minimum wage in some areas of the state, raising it to $15 per hour. Right now, upstate New York is at $9.70, and by 2020, the minimum wage will raise to $12.50. New York State, in its push towards a $15 an hour minimum wage, has instituted different minimum wages for different geographic locations as well as different industries. So if you're not located in upstate and you're instead in New York City or Long Island, you need to be aware that your minimum wage may be different than what is on this current slide. If you ever have a question about what it is, you can go to the New York State Department of Labor's website, and all of the rates are found, all of the minimum wage rates are found there fairly easily. In connection with the regulations which are incrementally increasing the minimum wage. In 2019, the governor had called for a safety valve to reassess whether or what economic impact the increased minimum wage may have. And it would allow the Department of Labor to adjust the minimum wage down or keep it the same if it looked like the increased minimum wage was having a negative economic impact. What's unclear is whether or not the safety valve applies to New York City and Long Island, or whether or not it applies only to upstate. So we'll keep an eye on that as we get to 2019. In New York, very similar to the federal law, an employee who is non-exempt must be paid for any overtime at the rate of 1.5 times their regular rate for all hours worked over 40 in a work week. The first challenge that we are going to address here is exempt versus non-exempt employees. A common pitfall that employers have is properly classifying employees as exempt or non-exempt. That's important because if you have misclassified somebody as an exempt employee when they should have properly been classified as a non-exempt employee, what that means is they may have not been paid the overtime rate if they worked any time over 40 hours in a work week. So generally, what's the difference between an exempt and non-exempt employee? As I alluded to, employers are not legally required to comply with minimum wage or overtime requirements for employees who are properly classified as exempt. Therefore, if someone is misclassified as non-exempt, they can make a claim that they should have been paid for more hours than they actually were. To determine who is an exempt employee, there are 3 tests: a duties test, a salary basis test, and a salary level test. So in order to be properly classified as exempt, you need to pass and meet each of these 3 tests, which we will go through in the coming slides. So let's first talk about the duties test. And the duties test really focuses in on what the employee does. It doesn't matter what the employee's title is. What we're concerned about is what the employee actually does. So that's something to keep in mind as we go through these slides. I will talk about the 3 primary white-collar exemptions. There are additional exemptions to what I will raise here today, but just for the amount of time that we have, I'm going to go through the 3 basic exemptions, and I'm going to go through them quickly. Much of the analysis that you do within, especially the duties test, is very fact-specific. So what I'll do is just give you an overview of the duties that each exemption requires. But generally, just keep in mind that it's fact-specific, and it really depends on what the employee actually does, not what their title is. So under the first exemption, which is the executive exemption, the employee's primary duty must be to manage the enterprise or manage a customarily recognized portion or department or subdivision of that enterprise. The employee must regularly direct the work of at least 2 full-time employees or 2 full-time equivalents. And the employee must have the authority to either hire and fire, or the authority or their recommendations with regard to hiring and firing must be given particular weight. The administrative exemption, this is really your back office exemption. So the overview for this exemption is that the primary duty, the employee's primary duty, is the performance of office or non-manual work, which is related to the management or operations of the business. So that is probably your HR functions, your accounting functions, much of your back office work. The employee must use independent judgment and discretion with matters of importance in connection with the performance of their work. The last general exemption that I will touch upon is the professional exemption. This exemption, the primary duty of the employee is the performance of work which requires advanced knowledge. That advanced knowledge must be predominantly intellectual in character, and the work must be performed with an exercise of independent judgment and discretion. The advanced knowledge also has to be in a field of science or learning, and it must have been acquired through a prolonged course of study. I will also mention that there's a creative exemption, creative professional exemption. That one is frankly rarely used, but it does apply where the work requires invention, imagination, or creativity. Before we move on to the salary basis test, I will mention the highly compensated employee exemption. This may come up in a manufacturing setting if you have technicians or other line employees who are highly compensated. There is an exemption for folks who earn $100,000 or more in a year. That being said, the DOL has specifically excluded blue-collar workers from the highly compensated employee exemption. So if you are a line employee, if you're a construction worker, even if you make up $100,000 in a year, you would not fall within that highly compensated employee exemption. So the second in the line of our three tests is the salary basis test. So the salary basis test requires that an employee, in order to exempt, must regularly receive a predetermined amount of compensation, i.e. salary, each pay period on either a weekly or less frequent basis. What that means is if the employee is ready, willing, and able to work, the salary must be paid in full for that week. What this means is that we can't deduct for certain absences, and we will go through what some permissible deductions are and what some impermissible deductions are. But unless you fall within the permissible deductions, the employee must receive their salary each and every week. So we'll begin with the permissible deductions. So any absence for sickness or injury, other than for another personal reason, you can deduct for a full day absence without violating the salary basis test, so long as the absence is for a personal reason other than a sickness or injury, or if the absence is because of a sickness or injury, so long as you as the employer have a bona fide plan or policy that indicates that an employee will be deducted for that day's absence if it's a sickness or injury. Now, that being said, under your plan or policy, you may still be compensating that employee because they have paid time off. So you would just essentially be substituting PTO for their normal compensation in that day, and that would be a permissible deduction. If, however, you don't have a policy concerning absences and sickness, you would not be able to deduct from that employee's salary for that full day absence. We can also deduct for a full day absence where the absence is due to a disciplinary suspension. The suspension must be imposed in good faith and for infractions of workplace conduct rules. There has to be a written policy, and the violation must be for a serious workplace conduct rule. So perhaps that's workplace violence, sexual harassment, something that's severe in nature. I would also note that when we're talking about partial days off, let's say, for example, an employee goes off, they leave at noon because they're sick or for personal reasons. You can require that employee, you can charge their accrued time for that partial day off. We don't have to not charge them for that partial absence. What we can't do is deduct for a partial absence. I would also note that if you are in the initial week of employment or in the termination week of employment, you don't have to pay the full week. So if you have an employee start working on Wednesday, you could prorate their salary for that week. You wouldn't have to pay them for Monday and Tuesday. Here are some examples of impermissible deductions that would violate the salary basis test. Deductions for poor performance, repayment for employer losses, which may include spoilage or breakage, cash shortages, loss or theft of equipment, fines or penalties for lateness, misconduct, or quitting without notice, recoupment of unauthorized expenses, fees, interest, or employer's administrative costs. Keep in mind that not only would these deductions make us susceptible to not meeting the salary basis test and therefore losing the exemption, they also probably, I would say, almost likely, I can't see one in here, that wouldn't also violate New York's law, which prohibits payroll deductions except in very limited circumstances. So not only do you have an FLSA exemption issue, but you also probably have a corresponding New York labor law violation for impermissible deductions. So what do we do to make sure that we are properly following and meeting the salary basis test? Well, you want to first review your payroll practices and make sure that we're not taking partial deductions for partial day absences, that we are not deducting for an employee who leaves early. So let's say, for example, you have an employee who is exempt and they leave at 3 o'clock. We can't deduct for them leaving early that day. We might have an attendance performance issue, but we can't deduct for them leaving early. We can't deduct for taking long lunches. Again, that might be an attendance or performance tardiness issue, but we can't handle that by deducting from wages. Additionally, the FLSA provides for a safe harbor that you as the employer can try and preserve the exemption even if there have been impermissible deductions. So in order to take advantage of this safe harbor, we need a clearly communicated policy which prohibits improper deductions and establishes a complaint mechanism where an employee feels that they've had an improper deduction. If, in accordance with that policy, an employee comes forward and says that there was an impermissible deduction, and you take a look at it and you say, yes, I agree with you, we will reimburse you for that improper deduction, and you take additional steps to make sure it doesn't happen again, you would be able to take advantage of the safe harbor provision and maintain the exemption for that employee, even though there may have been a mistake. So what I would suggest you do is take a look at your employee handbook or other policy that you have with regard to exempt employees or employee classifications. That's usually a good place to put in the safe harbor policy. If you feel that if you take a look and you don't have one, feel free to contact me, and I'd be happy to help set you up with one of these policies. And then the last test, which up until last year was pretty straightforward, is the salary level test. As many of you may be aware, there was significant discussion and scuttlebutt about changes that the Department of Labor had proposed and planned on enacting with regard to what the salary threshold was to be exempt. So as you may recall, currently the FLSA minimum salary level is $450 per week, which extrapolates to about over $23,000 per year. Last year, the Department of Labor tried to increase that from $455 per week to $913 per week, which translated to over $47,000 per year. there were a number of cases brought looking to block the DOL's rules from going into effect, and they were successful. Currently, there is a case pending in front of the Fifth Circuit Court of Appeals, and at this point, the salary level test has not been implemented, so we are still at the $450 per week level. At this point, it looks like it's unlikely that the Fifth Circuit would overturn the lower court's decision and allow this to go forward. The other change, obviously, has been the election, and we now have a Republican in charge. So it'll be interesting to see what ultimately happens with this, but I don't believe that we will end up seeing the changes that were proposed under the Obama administration. But not to be outdone, because we live in New York State, New York, and it's stricter than federal law. New York has its own minimum threshold for salaried employees. So these minimum levels, though, only apply to the executive and administrative exemption. It does not apply to the professional employee exemption, which is something to keep in mind. The minimum salary level, though, is not a set amount. It is actually tied to the minimum wage. So as the minimum wage increases, so does the salary threshold for exempt employees. So currently, the minimum wage is $9.70. The threshold for the salary threshold is actually 75 times whatever the current minimum wage is. So if you do the math, currently the minimum salary, or the minimum salary threshold is $727 per week, which is almost $38,000 per year. Again, keep in mind, because New York City, Long Island, and some of the downstate counties have differing minimum wage than upstate, that if you are a statewide employer, your minimum salary threshold will be different in different locations, just to make it as simple for you guys as possible, obviously. This is just a chart showing, as of December 2016, what the various thresholds are. And again, all of this information, as I mentioned, is also on the DOL's, New York DOL's website. Now let's move into some other challenges. Let's start with hours worked. Generally, employees must be paid for any and all time that they are suffered or permitted to work. What that means is you have to pay employees for any time that either you require them to work or you allow the employee to work. Even if you don't request it to be performed, if you have allowed the employee to work, meaning you know that it's happening, you have to pay the employee for that time. So some challenges that we see with regard to hours worked and whether or not employers, or some mistakes employers have made in terms of compensating for all hours worked, are preliminary and post-preliminary work, which I'll talk about that in connection with donning and doffing, travel time, training time, call-in pay. So let's first address preliminary and post-preliminary work. So employees must be paid, like I said, for any and all hours that they've worked. So let's say we have an employee who is performing work outside their regularly scheduled hours. If we know about it with either actual or constructive knowledge, we need to pay for it. If we ask them to perform that work, we need to pay for it. This comes up a lot where employees are able to have access to systems or to email after work hours, either through mobile phones, or maybe they can log in remotely to their desktop while they're at home. Those are the kind of situations that really present issues for employers. Given, I don't see this in a lot of manufacturing facilities unless we're talking about back office staff, either HR professionals, accounting professionals, things like that. to the extent that they are not exempt employees, you might have this issue, but your production staff, I would not anticipate having many of these issues if we're talking about doing work outside of normal business hours. The caveat to that is depending on if how your business is set up, if there's any paperwork or reporting that needs to be done, all of that needs to be done and compensated for. An employee shouldn't be punching out and then filling out either reports or paperwork in connection with even their line job or something like that. So in order to address this problem, you want to first make sure that your supervisors know that employees must be paid for all hours that they work. We are only as good and only as strong as our weakest supervisor. So make sure that you are talking to your supervisors, make sure that they are aware of some of these pitfalls, make sure they know what the rules are. Second, you want to make sure that your employees are accurately recording all of the hours that they worked, even if those hours are unauthorized. So even though they don't have explicit permission to work overtime, if they work it, you should pay it and make sure that they're accurately recording that time. If an employee is routinely performing work before or after their scheduled shift and it's not authorized, you need to handle that through progressive discipline, not refusing to pay them. Now, you might ask, well, what if you continue to have an employee do work even though you've explicitly said, you're not authorized to work overtime, you can't work overtime, I don't want you to do it. My advice would be to still pay them, even though they disregarded a direct direction. I would rather discipline the employee and fire them if I have to than not pay them for hours worked. I don't think the DOL will be sympathetic to that kind of an argument. So even if somebody has not listened to a direction, I would still go ahead and pay them for it and address it with discipline. Next, I'd like to talk a little bit about preparing and finishing activities, or donning and doffing. In the manufacturing setting, this is probably a common issue, especially depending on what your employees wear, what you require them to wear in terms of safety gear and things like that. So donning and doffing generally is the practice of putting on and taking off safety equipment and or clothing. Generally, in order to be compensable, donning and doffing is or has to be integral and indispensable to the employee's principal work activities. While this sounds simple, there are a number of court cases, and the application is really quite fact-specific. And while we have a general rule, depending on the nature of your business, the nature of the gear that the employees are required to wear, the answers differ. And frankly, the courts are having difficulty applying a black and white rule. So generally, though, donning and doffing, so like I said, the taking off and putting on of safety equipment or other gear will only be compensable if the nature of the job mandates it and it occurs on the employer's premises, meaning the employee can't put on the gear at their own home. And a lot of that is dictated by the reason why they have to wear it. Some examples include, like I said, putting on and taking off protective gear, and that can range from putting on a hard hat to putting on goggles, earbuds, things like that I would say are probably not compensable, to putting on full-out hazmat gear, depending on the industry you're in. Something like that, especially if you are required to put on either sterile gear or extensive hazmat material, those types of things are probably compensable. Another example is pre or post-shift showering, especially if those types of things are required by law or regulation, or the employer requires it to be done. Those things will probably have to be compensated for. there is a de minimis exception. Any minor or trivial work that is performed outside of the scheduled working hours does not have to be compensated for. That generally means 10 minutes per workday. So if we think about the example of a hard hat, safety glasses, or earbuds, those types of things generally would take less than 10 minutes per day to put on. So even if they are required by law, required by the employer, and you have to put them on at the workplace, it's more than likely that the amount of time spent doing those things would be less than 10 minutes per day, and you would fall within this de minimis exception. But, you know, what you want to do to make sure that you're not running into an issue or you don't have an issue, you really need to go through the analysis. Figure out what, if anything, our employees are donning and doffing. Figure out whether they're doing it before or after they punch in and out. How much time is spent on those activities, and are the activities integral and indispensable? Do we require that it be done at the facility? Is there a regulation that requires it to be done? Do we have an employer policy requiring that it be done? Think about whether or not the donning and doffing activity can be done at home, or whether or not you have to have them do it at the workplace. And then lastly, enforce any directive and discipline where necessary. So if you tell employees to put on their steel toe boots at home, if somebody doesn't do it until they show up at work, make sure that you handle that with discipline and performance management. The next topic we'll cover here is travel time. And this one will be pretty quick. I don't see this as a huge issue for manufacturers, but I wanted to make sure we addressed it at least just a little bit. Generally, travel time, if it's regular commuting time, that is the employee traveling to and from the workplace from their house, is generally not compensable time. That being said, if an employee is making a special trip to a meeting place or some other a client, or going to another employee's house to drop off tools or equipment, it may be that time spent traveling in connection with that special assignment is compensable. This is a very fact-specific analysis, so if you have these issues come up a lot, I would suggest you ask me more questions about that. But generally, commuting time is not compensable. Special one-day assignments is another one that is often asked about, although might not be a huge issue for manufacturers. But travel time for assignments that cover longer than the employee's day are typically compensable. So let's say an employee typically works from 9 to 5 in Buffalo. They have an assignment, a special one-day assignment in Albany. The employee leaves at 8 in the morning to get to Albany and is back in Buffalo by 7 p.m. The compensable time would be 8 a.m. to 7 p.m. Any time spent from commuting to, in this situation that's on the slide, the employee picks up a coworker. You might not necessarily have to compensate from the employee's home to the coworker's home, but the remainder of the travel time for that travel day would be compensable. Training time, I think, is something that you as manufacturers probably have to deal with, especially if you have safety roundups at the beginning of your shifts, or maybe you have annual or quarterly safety meetings. Any attendance at meetings, trainings, programs, lectures must be paid. The only exception to that is if all of those 4 factors are met. The program or the training is outside of normal hours. It is completely and utterly voluntary. It's not job related, and there's no other work that they're also performing in connection with that training. So to tackle this problem, make sure that your supervisors know what the process is and what the rules are for travel time. Make sure they know to come to HR with any questions. And like I said, our weakest link is usually at the supervisory level, and we want to make sure that our supervisors are fully trained on some of these issues. And even if they don't know completely how to handle it, if they know how to issue spot, we're in a better place. So another interesting issue that has come up recently because of some concerted enforcement efforts by the Attorney General is call-in pay. In New York, generally an employee who is requested by their employer to report for work on any day must be paid for at least 4 hours or the number of hours in the regularly scheduled shift, whichever is less. So if the regularly scheduled shift is only 2 hours, we would only have to pay 2 hours of call-in pay. And the payment has to only be at the basic minimum hourly wage. So whatever New York State's basic wages that applies to you depending on your location. So we would not have to pay them 4 hours of call-in pay if they earn above minimum wage, at whatever their regular rate is. So again, if you have an employee who is called into work, they must be paid for at least 4 hours or the regular number of hours in the regularly scheduled shift, whichever is less at the basic minimum wage. As I mentioned, the Attorney General has really pushed recent enforcement action on this. He's focused on the retail industry at this point, but the crux of it are those practices or those employers who have practices that schedule an on-call shift. So let's say, for example, you have employees who are on call for certain shifts during the week. The Attorney General has said that just by virtue that they are on an on-call shift, that may implicate the call-in pay regulations. It's unclear. He has not formally opined on this, but he has reached settlements with a number of large retailers, including Disney, Abercrombie & Fitch, Aeropostale, PacSun, Zumiez, a number of large retailers. So just something to keep in mind if you guys do have a scheduling practice where you have employees who are scheduled to be on call, that may implicate the call-in procedures or the call-in pay provisions. So some things to think about in terms of addressing this issue. Take a look at your pay practices. What are your call-in pay policies and practices, and make sure they comply. Keep in mind that as the minimum wage increases, so do the concerns about whether or not you're complying with the call-in pay procedures, because the back pay liability increases. Keep in mind that different regions, different geographic locations, and therefore different facilities may have different obligations with regard to what that minimum wage is. And think about, if you do have on-call shift scheduling, whether or not you want to keep that in place. I next want to talk about breaks and meal periods, and this across all industries is probably where I find the most issues from employers. I'll just give you some of the general rules when it comes to meal periods. Employees who work a shift of more than 6 hours must be provided a meal period of at least 30 minutes. Employees on shifts beginning before 11 a.m. and ending later than 7 p.m. must be, in addition to that 30-minute meal period, given an extra 20-minute break between 5 p.m. and 7 p.m. And any employees who work in excess of 6 hours during the period of 1 p.m. to 6 p.m. are entitled to a 45-minute meal break, and it's 60 minutes for factory employees. So factory employees have additional mealtime requirements. That being said, the New York DOL has put out guidance that indicate that you as an employer can, without approval or application to the New York Department of Labor Commissioner, shorten meal periods to no less than 30 minutes. So even though you're a manufacturing employer who might otherwise be obligated to provide a 60-minute meal period, we can shorten that meal period to 30 minutes without application to the Department of Labor, so long as there is no undue hardship to the employee. So before you go ahead and implement that, what I would suggest you do is figure out whether or not there's an undue hardship. The policy reason behind the 60-minute meal period provision for factory employees is to allow for walking from the production floor to wherever the break area is, and to allow for those employees to punch in and out. So you have to think about how your facility is set up. So if you decide that you want to shorten the meal period to 30 minutes for your production employees, you need to make sure that it's not taking those employees 20 minutes of that break to get to and from wherever the break area is. They should have 30 full minutes to eat. So I think the DOL, when they're looking at whether or not there's an undue hardship, will take into account how much time it takes employees to get from the production floor to the cafeteria or wherever it is, and ensuring that those employees have 30 minutes to eat. One employee shift exception when it comes to meal periods: if you happen to have an overnight production shift, but you're small enough that you might only want one employee there, we do not have to relieve that employee of that meal period time, so long as the employee has consented to the arrangement, and we'll go through the requirements. So the DOL requires, in order to meet this exception to the meal period requirements, you as the employer must explain to the employee that the nature of the position requires that the one employee shift, that it's a one employee shift, and that explain to that employee that their meal will be interrupted. You need to get an acknowledgement from that employee, preferably in writing. A lot of times the DOL thinks that if it's not in writing, it never happened, that they have acknowledged and accepted the arrangement. And then you also have to pay the employee for that meal period. So while they don't have to be relieved of duty, they can eat during that meal period, but they also have to be paid during that time. So some best practices when we're talking about meal and break periods: determine if all of your employees are receiving their required meal periods. Make sure that you have trained all your supervisors and managers about the meal period rules. If you're relying on the one employee shift exception, make sure that you've complied with the DOL requirements. Develop and revise your meal period policy. Make sure that employees report to you and have a mechanism to report to you if a meal period is not provided. And then, like I mentioned, you want to make sure your supervisors are trained on your meal period obligations, both under law and your policy, if your policy is a bit more strict than the New York labor law. Make sure that a supervisor knows that if an employee is interrupted throughout their meal period, that they must be compensated for that time. And then hold supervisors who don't comply with these obligations accountable. That means discipline. For those of you who automatically deduct time for meal periods, proceed with caution. Both the New York and U.S. Department of Labor really frown upon these kinds of arrangements. You need to make sure that you let employees know that their meal period is automatically deducted, and make sure that they know that if they do work through a meal period, that they know who to contact to let you know that they worked so that they can be compensated for that time. So again, you'll want to develop and promulgate a policy, make sure it's followed and enforced, advise the employees of the deduction, require employees to take action to correct the time records, counsel and discipline employees if you find out that they have not taken those steps. And again, direct your supervisors to make sure that time records accurately reflect employees' work hours. And again, counsel and discipline where appropriate. Then the last topic we'll address is timekeeping and record-keeping requirements. So typically, if any of you have been through an audit, you will know. And for those of you who have never been through an audit, I will tell you that your time and payroll records are at the center of any audit that you have. That's what the either New York or DOL will want to see. And it's those payroll records that they will determine whether or not there's a violation. There's no specific form that you have to get them in, but federal law does require that you be able to get them, and they can be produced in a form that the DOL can inspect them in within 72 hours. So not only do we want to make sure we're keeping records, but we want to make sure that they're accurate. One, it's not, we're obligated to make sure the records are accurate. And if our records are not accurate and reliable, it may indicate to the Department of Labor that supervisors have directed employees to falsify time records, that supervisors have altered records where it's not a legitimate reason, or the employer knows or has reason to know that for some reason the records are inaccurate. If your records are inaccurate and unreliable, what that means is that the Department of Labor, both federal and state, will take the employee at their word about what they had worked. So where this comes in, and I would actually advise, even for your exempt employees, to make sure that they punch in and out and keep record of hours worked. The reason being, this comes up a lot where you're dealing with the misclassification of an exempt employee. So we have, perhaps an employee who's kind of in the gray area, or maybe their job has changed over the years, and what was exempt is now not exempt. The employee, when they are during a DOL audit, will interview an investigator or auditor. And the auditor will ask, well, on average, how many hours per week do you think you worked? Not shockingly, most employees, say, oh, I worked, 50 hours or 55. It's typically more than what the employer thinks that they were working. Without having records of what the employee was working, the DOL will take the employee at their word for the number of hours that the employee said that they worked per week. Obviously, that will have a significant impact on what the DOL calculates your ultimate back pay liability to be if there's a violation. So make sure that your records are accurate. It is your best defense in any audit and any claim for unpaid wages. So to address some of these challenges, look at what your record keeping policy is. Make sure that employees know. And it's simple enough to include in the handbook or wherever you have your policies. Make sure that employees know that they have to accurately record their time, not just their scheduled hours, but their hours actually worked. If you are rounding, if you have a rounding program or policy, make sure that it's defensible, meaning that the way that you round is fair. And if you have questions about that, I'd be happy to answer more specific questions about those. Again, educate your supervisors. Make sure that they know that they can't just alter time records without some explanation as to why they are changing it. And make sure that they know that they cannot instruct, direct, or ratify the falsification record. So even if they're not doing it themselves, make sure they are not advising employees to put down something different than what the employee actually worked. And then make sure that you keep your payroll records for as long as legally required. New York State requires that we keep them for 6 years. There may be circumstances where you feel it's more appropriate to keep them permanently. Obviously, depending on the size of your business, that may not be feasible, but something to consider that you need to keep them for at least 6 years. All right, so I see that we have some questions, so let me pull this up. It'll just give me a few seconds to run through them, because it'll take me some time here to see. I have quite a few, so let me see here. One of the questions we have is, how many employees must a manufacturer have before these various laws apply? The answer is 1. The number of employees, especially for state law, so long as you have 1 employee, the laws apply. To be subject to the Fair Labor Standards Act, that's a more difficult question and relies on how much productivity, how much you're producing. If you're doing more than $500,000 of business, which impacts interstate commerce, the FLSA applies. So if somebody has a question about that more specifically, I'd be happy to talk to you about your specific situation, but generally these laws will apply to most of you on this call. I have another question, salary deductions for jury duty. All right, so we cannot deduct for jury duty for absences related to jury duty. What we can do is offset for any monies that they are paid through the court system. So I think the amount now is you can get $40 per day for jury duty. So what you would be able to do is offset that employee's salary offset the salary for whatever monies they've earned. But we can't deduct for absences in connection with jury duty. Okay, I see a question about the slides, and Kathy, you answered that, so I'll skip that one. The call-in pay question, the question is, call-in pay only applies to employees who are on call. I'm not sure I understand that question. So I have your name, the person who submitted that question. What I will do is reach out to you after this and get some more information about what your question is. Okay, how do you document or handle employees who choose not to take lunch break but work 6 or more hours? You have to meet with them, make sure you go over the policy with them. So a lot of times employees will want to leave early at the end of the day. That's not acceptable. We have to, I know it's what's more desirable for the employee, but for you as the employer, you have to do what the law tells you, which is that they have to be given a meal break. So if they refuse to do it, then I would meet with them. I would train them on our policy and on the law. I would document that conversation. It doesn't have to be anything more than a memo to the file. And if need be, I would give verbal, written warnings, suspension, and if you have to, it may end up in termination. It's not something that you want to have to do, but especially if they're a good employee. But you know, you guys have an obligation to make sure that we're complying with the law, and if the employee refuses to do that, then we need to address it. Okay. Okay, so regarding automatic deductions for meal periods, what is the safest practice for addressing an hourly employee who works through lunch because they are busy? If that is a significant significant issue for your workplace, meaning there's more than just one employee, I would suggest you not automatically deduct and require employees to instead punch in and out. If this is a more limited problem, so even though you are going to automatically deduct, but for the most part it's not an issue, but for a few, I would make sure that that employee supervisor is on top of them to ensure that the employee reports on those days that they work through lunch and make sure that they are paid for that time. If they're not paid for that time, if the DOL comes in and sees that it's automatically deducted and that employee says, actually, I work through lunch 4 out of the 5 days every week, well, that means that the employee has to be compensated for whatever their regular rate is for that time, and that also counts towards their hours worked for overtime purposes, so you may also be bumped up into talking about overtime. So I would look closely at your automatic deduction policy, and if the employee's busy and we're talking about the fact that working these extra either anywhere between 2.5 to 5 hours in the week bumps them into overtime, I think you have a problem. So for the person who submitted that question, I'd be happy to talk to you offline in more detail about that. And then I also see a rounding question. Is rounding to the lowest quarter hour permissible? Yes, it's permissible. Just make sure you're doing it so if you're going to round up, if they've just make sure you're doing it in the fairest way possible. So if the employee, let's say their shift starts at 8 a.m. and they punch in at 7:55, it's all right to round up to 8 a.m. But if they punch in at 7:50, make sure you're rounding down to 7:45. So just make sure that, yes, you can round to the quarter hour, just make sure you're doing it in the fairest way possible. All right, and we are out of time. There are a number of questions here that have not been answered, so I will try and reach out to those who have submitted questions and answer those with you offline. Thank you all for attending. As I mentioned at the beginning, we still have 2 days left, and we'd love to see you guys on the remainder of the segments we have for tomorrow and Friday. Thank you all, and like I said, I'll be in touch with those who submitted questions that I couldn't get to.